Coincidentally is when we started doing these webinars. During the heart of the pandemic, we were doing them weekly, and we dropped back to monthly now, which seems to be a good cadence for us and for you. So glad you're here with us today. I see a lot of people that I do know on the line. I also see some people I don't know. So for those of you that I've not had the pleasure, I'm John Miller. I'm the founding attorney of Rock Solid Law and Title. I left downtown Jacksonville and formed my own firm in 1991, actually right here in Ponte Vedra, where I'm sitting now, and have carried on that practice then to now. At the time I left being an associate attorney, I was a litigator. I was a business litigator, and I transitioned into being a business transactional lawyer, which really I've often called the care and feeding of small business owners, and realized back then in the 90s that to successfully represent them, I needed to understand their personal side as well. Couldn't plan the transition of a small business without knowing the people that owned it, 2-3 folks usually. And that led into the estate planning side of our practice, which now is a significantly larger part of the practice than the business practice, although representing entrepreneurial small business owners is just near and dear to my heart, and we love doing that work. Have the opportunity, both Walt Unfricht, the other attorney here, and I will both be doing some business work today, in fact. Anyway, I believe that small business is a heartbeat of the American economy, is most of American business, and employs most of the working people in America, and love doing that work. And of course, the people that run the small businesses are other families like yours and mine. And 95% of everybody needs to have an estate plan in place. About 80%, I believe Dave Ramsey would tell you, it might be higher, of Americans who should have a plan don't. Even a simple will-based plan, and it causes problems after when people die. So one of our quests here is to get people to engage in values-based estate planning, get a plan in place, update it regularly, and plan for all sorts of things. Plan to miss probate because that's expensive and it's where families go to fight. Plan to not pay more taxes than are necessary. I like to say that our clients only pay the mandatory taxes, not the voluntary ones. All right. And that leads us to the subject matter that we're going to talk about today. You heard the name of the firm. The last several syllables are "and" title, last 3 syllables. So obviously we close real estate professionally and on time. I love being involved in Northeast Florida real estate. Quick pitch, 2 quick pitches. One of my volunteer things is with the Beaches History Museum. And tonight, if you're watching this live, is the last of the chapel concerts of the year. I'm on the committee that puts them on. We have an amazing performer tonight at 7 o'clock. His name is Webb Wilder. As one of the bonuses of watching this program, if you are interested in attending, shoot me an email, use questions at Rock Solid Law, and I've got a special ticket deal for you on the show tonight, since it's our last one of the year. Second thing, most of you know that since 1973, so for 50 years, I've been performing and recording in blues and rock bands. And my rock band, blues rock band, whatever you want to call Bay Street, will be celebrating our 36th anniversary in July on the 12th at the Blue Jay in Jacksonville Beach. Tickets are limited. I believe they're on sale. If not, they will be very, very soon. And we would love to see you there that night. Okay, that's all of the promo I've got for you as we move into the heart of this webinar. I will make a hangout to the end, and I want to offer you an opportunity to come in and talk to us without charge about the subject matter of today's webinar or anything else to do with estate planning. So I told you how I got into estate planning and why I got into estate planning, but from then to now, it's really become important to me because I consider our firm, Rock Solid Law, as an anti-probate device. In other words, I want to keep people out of probate. And these trusts that we're going to talk about today are the best way to do so. I also consider us preservation lawyers, family preservation lawyers. You know, the divorce lawyers have stolen the term family law. Well, it's not really family law. It's divorce law that they do, right? So I want to be the family preservation firm to keep families together through multiple generations. There's nothing that pleases me more than when our firm serves a family and keeps it strong throughout the generations. You know, last fall, we sent out a survey asking what people would like for us to teach, obviously in our subject areas, on, and one of the highest suggested areas was, what is the difference between a revocable trust and an irrevocable trust? Now, first and foremost, pronunciation. They're both correct. I've been to the dictionary. Okay, you can say revocable, you can say revocable, you can say irrevocable, you can say irrevocable. Today, I'm going to choose revocable and irrevocable. The reason I'm going to say them differently is so you'll know which one I'm talking about, because a revocable and irrevocable sound an awful lot alike. So I'm only going to talk about revocable trust with that pronunciation. And then when we shift in the irrevocable trust portion, I'm going to pronounce it irrevocable. Okay, just hang with me. Neither one is wrong. And that leads me to my next point. By staying online this morning, I'm asking you to agree that this is a no judgment zone. If you need to do so and time allows, put a question in the question and answer or the chat board, and I will address those toward the end of our time together this morning. No question is a bad question except an unanswered question. However, there are questions that are very personal in this subject matter. So if your question or a question that you have is very personal or is significantly based on facts personal to you and your family, let's send those in to us at questions@rocksolidlaw.com, questions, plural, at rocksolidlaw, the name of the firm.com. And we can take those offline and answer them privately, right? So no judgment zone, no bad questions, two ways to ask them. So revocable trusts. A revocable trust can have many names. It's the same thing. I get asked this all the time. A family trust, a living trust, an inter vivos trust, which is Latin for living, or a revocable trust, all the same thing. Is every trust drafted the same? Absolutely not. In fact, I would say no two trusts are drafted the same, because no two families are exactly the same, and the values of no two families are exactly the same. We take a values-based approach to your estate planning, which means you tell us what you're trying to accomplish, and we draft to get you there. You can be as involved in understanding what it all means, what the words mean, what those clauses in your trust mean as you want, or you cannot. I have some people that say, here's the goal I want to accomplish. Do these words accomplish it? Good, let's do it. I have other people that want to understand what sub-trust that's contained for future tax considerations in their trust are. Fine, we'll talk about those as well. All right. So all of those terms are a revocable trust. Revocable meaning that the trustees can amend or change it anytime they want, or they could terminate it if they decided they wanted to. Few people actually terminate their trust, though many people don't use them properly. And here's my pitch for funding. Funding is a term of art in the law of estate planning, meaning retitling your assets into your trust. The trust, by and through its trustee, can only control those assets that have been moved into the trust. Let's assume there's John Miller and there is a John Miller trust. I'll tell you there isn't. So this is totally hypothetical. And John Miller has 3 bank accounts. If I move 0 bank accounts or retitle 0 bank accounts into the name of the trustee of that trust has control of nothing. All right. If I move 1 bank account into the trustee has control of that, and so forth. If all of them are moved over there, then the trustee has control. John Miller doesn't. Now, it may be the case, or it may not, that John Miller is the trustee of that trust. So I may still have control with my trustee hat on, where I don't as myself. Why is that important? Because I've named a successor trustee. And the day after I'm through with all of my worldly goods, whoever I've appointed as trustee of that trust is in charge. A judge is not in charge, right? And we have some darn good judges, but you know they're elected or politically appointed. And for me, I would much rather choose who's going to be in charge of your estate, your family's estate, your friend's estate, everybody's family's estate, than have to go down there and get a judge's approval, review, and then have everything slowed down while you go through the court process. So what does a revocable family inter vivos living trust do for you primarily? And I've taught this course, and if you really, really, really want to hear about those, go to Rock Solid Law /videos page, and you can review every single webinar I've ever done. But there are ones on the family trust there. So first and foremost, I just inferenced it. They keep you out of court. Why do you not want to go to court? It's expensive. And the worst thing is it's where families go to fight. You give people an arena to fight in, and somebody is going to have some emotional issue from childhood that they're going to take out on the others in court, and it can drag on for years. So the distribution can be delayed well past when somebody might need it. All right. So that's the first thing a revocable trust can do. The next thing is, for the assets it controls, it can determine when the distributions take place and under what circumstances. Just a couple quick examples. Some of the worst things in the world is an 18-year-old inheriting $1 million because time and time again, it's gone by the time they're 20, right? Then they live a life of regret that they blew it. And they had an opportunity for everything, and it evaporates because they're not mature enough to make those decisions. When do they become mature enough? You have to decide that. The person doing the trust says, let's give them some in their 20s, but hold back for the 30s, even into the 40s these days, folks, because nobody wants to wait, but nobody doesn't appreciate the foresight of the gift givers, their parents, of holding that money as a safety net for later in their lives, so that it's grown over time and it really helps them out. And this protects your legacy. Wow, all those years later, they get this gift and you're gone and they're just grateful to you. You know, one of the things I've heard is you die twice. The first time you die is when you take your last breath, and the next time is the last time someone thinks of you. So one of the legacies we create is happy, grateful thoughts well into the future for what you may have chosen to leave behind. So for that base level trust, okay, and I call it base level, but it's what most families with any reasonable degree of assets need to have in place so that they don't go to court and lose 3 to 10% of it through the probate process. All right. You want your money to go to who you want your money to go to. I don't care if it's a charity. I don't care if it's your kids. I mean, wherever you want it to go, that's where we help it along. We just hold its little hand and get it to where it needs to be in your documents. And we create those documents so that that flow occurs in the manner in which you want it to occur. Now, the important thing to know is that with a living trust, a revocable trust, there is no asset protection in the trust document itself. Okay, you keep complete control. For those control freaks among us, you keep complete control of your assets, right? But you have not asset protected them. And if you wish to asset protect them, we need to look at a different kind of trust. And so therefore, I want to switch to irrevocable trusts. And irrevocable trusts are many, many different kinds, okay? But the basic idea is either to protect assets from outside creditors, or maybe from the very person you're trying to benefit, or to create tax benefits in your lifetime and throughout the generations, okay? So a discussion of those goals is beyond what I'm going to have time to do today, but hold on, because this is a roller coaster ride, and I want you to understand a little bit about irrevocable trusts during the time that we have remaining this morning. So the purpose of asset protection is to give you negotiating leverage against future potential creditors by making it difficult for a creditor to collect against you. A creditor is generally only able to collect against what you own in your individual name. Got it? We're moving things out of that. When you create an irrevocable trust for the benefit of another and place property in that trust, the property placed in the trust is no longer owned by you and should be able to collect, not to be collected against. Excuse me, I'm gonna have a sip. Similarly, if you are the beneficiary of an irrevocable trust created by another person, you're not the outright owner of those assets, but merely entitled to receive distributions from the trust as the trustee decides. Therefore, it's difficult for a creditor to collect against a beneficiary's interest in a trust the beneficiary did not create. If you put a significant portion of your assets in an irrevocable trust, retaining only your homestead and protected retirement accounts assets in your own name, it will be very difficult for a judgment creditor to collect against you. A trust can help you navigate specific tax concerns or creditor protection, ensure your wealth supports your family, or leave a legacy for a charitable cause that you believe in. So there are multiple kinds of irrevocable trusts. You typically cannot change or amend an irrevocable trust after it's created, with certain caveats that are beyond what we're going to talk about today. The assets move out of your estate, and the trust pays its own income tax. You have to get an FEIN, and files a separate tax return. This can give you greater protection from creditors we've mentioned, but also from estate taxes. You can set up your revocable trust to automatically create irrevocable trusts at the time of your death. We've talked about that in these sessions before. That's a family by family decision. It's very fact-based, but in many cases, on the death of the first of a long-term marital partnership, the trust becomes irrevocable. The why is a little beyond what we have time for today. But you can also create irrevocable trusts during your lifetime, of course. As I've said, there are a variety of irrevocable trust types to choose from, depending on your unique or individual circumstances. Your reason for setting up an irrevocable trust is critical in helping you select the one that fits your needs. Here are the questions you're asking yourself, or we would ask you to ask yourself. Are you setting up the trust to transfer wealth to the next generation, keep a family business in the family, leave a legacy with a charity of your choice, minimize estate taxes for you or your beneficiaries, or shield your assets from creditors? It's kind of a fun little twist that often one stumbles upon when saying shield your assets. So irrevocable trusts include irrevocable life insurance trusts, often called ILITs, and they're set aside. They're to set aside funds for estate taxes. An ILET might be particularly useful if you own a family business that's set to remain in your estate when you pass away. You can create an ILET ahead of time to ensure the business stays in your family despite estate tax bills by gifting the premium on your life insurance into the ILET each year. There are also grantor retained annuity trusts, or GRATs, and qualified personal residence trusts, CUPERTs. There are certain irrevocable trusts that are intended to last for only a specified term of years. Two examples are the GRATs and CUPERTs. Charitable remainder annuity trusts, special needs trusts. If you have a child or family member with a disability, you might consider setting up a special needs trust. Special needs trusts are typically created for individuals who are eligible for some government benefit due to the disability, and they're created so that they support after those government benefits are made available to the person, and then obviously are used for other needs that they have. I often get questions about generation skipping trusts, because these are often written into a revocable trust as an option that the successor trustee has at death. So a GST, or generation skipping trust, is a trust people often choose for tax reasons. With this type of trust, you designate assets to your grandchildren, skipping your children in order to bypass estate taxes that would occur if they directly inherited your assets. Obviously, fact-centric to every different family. Additional trusts that are irrevocable are credit shelter trusts, irrevocable family trusts, spendthrift trusts, and Q-tips, qualified terminable interest property trusts. And we just discussed the special needs trust. So as you can see, there's no one bucket fits all. There are many, many different opportunities and avenues, and it requires knowing the particular facts of every family. You would be surprised at how often somebody says, well, my family's different. And usually they go on to tell me some nuance that I haven't had before. But often the issues that are in one family repeat in another, and the opportunity to help someone who may have strayed from the path get back into leading a life that is productive and a positive life is there by drafting in certain requirements before they can inherit the money. An example would be with the opioid issue that we so often face these days, drafting in that if the trustee suspects addiction, that the trustee can provide for rehabilitation, but cannot provide inheritance until the person can test clean. Illegal drugs, legal drugs, we can get any of those things in there for you. If you suspect, or even if you don't suspect, often we put those in there when there's a baby, a minor child. We don't know how they're going to turn out, but let's help create some guidelines that are consistent with your values. So I've talked out of time again. I'm really good at that, huh, guys? So I would be delighted for us to sit with you or anyone that you know that needs to do this as a result of your attending this webinar this morning. If you will just mention to my team when you make the appointment that you were on it, I will waive the consultation fee. That's nearly a $500 benefit or gift to you. And we could talk about your specific situation and whether one of these trusts fits your family correctly or you individually. Trying to have favorite clients, but one of my favorite clients is an older gentleman just really doesn't have any family, and he's leaving everything to charity. And I just love being the lawyer that gets to help him out. So the way it works for our firm, we do good work and people tell each other about us. So we want you to become the next satisfied client so that you'll tell all your friends about us. I know I see some already friends on the call today. Thank you. It really, it makes my heart full that you keep coming back for more education. I had somebody yesterday and she brought her sister-in-law in, and I was consulting with the sister-in-law, and my existing client kept answering the questions, and she goes, see, I was a good student. So she had learned a whole lot about estate planning and trust through her own process. So it's just a joy to get to help families out. Preserving Florida families is an honor and something that we here at Rock Solid Law take as a gift and an opportunity to help for something that we've spent a career learning how to do. So there you go. I really, really appreciate so many. There's a large group online today. So if you have questions, I'm just going to ask that you submit them to questions, that's plural, at rocksolidlaw.com. If you forget that, give us a call. And many blessings to you and yours in this beautiful Northeast Florida day. I am John Miller, founding attorney, senior attorney at Rock Solid Law and Title. Thanks for spending the time. Welcome. How people are still jumping on.